Welcome back to the Deep Dive, where we take complex procedure and distill it into immediately useful, actionable knowledge.
We are deep in the Manual of Patent Examining Procedure, the MPP, specifically Chapter 1400 on the correction of patents.
And today's focus is MPP Section 1449. This section tackles a real tricky spot.
It really is. It's about what happens when a reissue application that's, the attempt to fix errors in your patent collides head-on with a contested case.
Like an IPR, a post-grant review, maybe a derivation proceeding, something happening before the Patent Trial and Appeal Board, the PTAB.
Exactly. Or even older interference proceedings for pre-AIA patents. It's this collision of trying to fix the patent internally while it's being challenged externally.
Yeah, it sounds like a fundamental clash. You've got the patent owner trying to quietly correct things via reissue, and then you have this very public, often aggressive challenge trying to invalidate those exact same claims at the PTAB.
Precisely. And our goal today really is to unpack the office's mandatory procedures here. It's like an administrative checkmate designed to stop claims that are being actively challenged or maybe already found unpatentable from somehow getting allowed through the reissue backdoor.
It's about procedural integrity then, making sure one process doesn't undermine the other.
Absolutely. Maintaining the validity and finality of what happens in those contested cases is key.
Okay, let's dig into this. How does the office handle this collision right when it happens? So normally a reissue application goes to a regular examiner, right?
That's the usual path, yeah.
But if that same patent is already tangled up in a contested case like an IPR, you said the office has to slam on the brakes for the reissue.
That's a good way to put it. The brakes go on. But there's a specific trigger mentioned in MPP Section 1449.
What's the trigger?
It's the filing of a protest related to that reissue application.
Protest. So not just any communication, but a formal protest.
Right. And this is important context. A protest isn't just an informal heads up. It's typically filed by a third party, an adversary often, arguing why the claims in the reissue shouldn't be allowed.
And they'd likely point to the ongoing PTAB case as a big reason why.
Exactly. They're essentially raising a flag saying, hey, hold on, this patent's validity is already being seriously questioned over here at the PTAB.
So that formal protest is the alarm bell that forces the examiner's hand.
It is. Once that protest is filed, the MPP instruction is crystal clear and mandatory. The reissue must be referred directly to the Patent Trial and Appeal Board.
Directly to the board. Wow.
Yes. And crucially, the rules state no further action can happen on that reissue application until the PTAB finishes its review related to the contested case. The reissue is effectively frozen.
That's a significant shift. The examiner loses control, and the board takes temporary oversight of the reissue itself.
Pretty much. And there's another layer here. The reissue application cannot actually be allowed without the explicit approval of an administrative patent judge. An APJ has to sign off.
Why that specific judicial approval? Why not just let the process resume after the PT case finishes?
It's all about synchronization. Imagine the PTAB is literally days away from issuing a final written decision finding claims 1 through 5 invalid in an IPR.
Okay.
If the examiner, unaware or acting independently, allowed a reissued patent with those same claims 1 through 5 just before that decision dropped, well, you'd have chaos. Conflicting outcomes from the same agency.
Right, the whole system's integrity would be shot.
Exactly. Requiring an APJ's approval ensures the board, which is handling the high-stakes contested case, confirms that allowing the reissue won't contradict its own findings or ongoing proceedings. It prevents patentees from, maybe trying to sneak potentially invalid claims through the reissue side door while the main challenge is happening. And this need for coordination, the synchronization, it isn't just limited to PT trials like IPRs or PGRs.
Okay.
It also applies when a reissue application overlaps with a reexamination. Could be ex parte or inter partes reexamination.
Right. Because that's another path where patent claims are being reviewed post-grant. So similar potential for conflict.
Precisely. You could have two different parts of the USPTO looking at the same patent, maybe even the same claims, at the same time. That's inefficient and risky.
So what does the office do then, if you have a reissue and a reexam running concurrently?
The regulations, specifically MPP Section 279, which is cross-referenced here, give the office flexibility. They basically have two main options.
What are they?
First, they can merge the proceedings.
Merge them. How does that work?
They essentially combine the reissue file and the reexamination file into one single prosecution history. Everything gets handled together, leading to just one certificate issuing at the very end that reflects the outcome of both.
Okay, that sounds efficient, like the preferred route.
Generally, yes, it streamlines things, avoids duplication of effort.
Makes sense. What's the second option?
The second option is to suspend one proceeding until the other is resolved.
Suspend. So just put one on ice completely.
Yeah. Though the MPP notes suspension is usually for more, let's say, extraordinary situations. Maybe letting one conclude first will significantly simplify the issues in the other. For example, suspending a first re-exam to let responses come in for a second re-exam before deciding to merge them. The ultimate goal is still consistency and efficiency.
Now, here's something I find interesting. The MPP says the burden is on the patent owner to notify the office about these concurrent proceedings. They have to file these notifications of concurrent proceedings.
That's right. It's their responsibility.
But wait, wouldn't the office's own internal systems, their databases, flag that the same patent is involved in multiple proceedings? Why put the onus on the patent owner who, frankly, might not be super eager to highlight the conflict?
That's a really practical point. And yes, internal systems likely do catch many of these overlaps. But the formal notification requirement serves a crucial purpose.
Which is?
It creates a clear, undeniable, documented record provided by the patentee. It removes any ambiguity. If the patent owner files both a reissue and, say, an ex parte re-exam, they must tell the office formally.
Ah, so it's like an official declaration.
Exactly. It acts as a procedural safeguard. It ensures that the important decision whether to merge or suspend is made deliberately based on formal notice, rather than just hoping an automated system catches it perfectly every time. Database glitches happen, or maybe claim numbering is slightly different. This forces the issue into the open formally.
Okay, so let's jump ahead. Imagine the PT trial, maybe the IPR or the reexamination, finishes up. The final decision is made. The certificate detailing what happened, claims canceled, amended, confirmed, gets published.
Right, the dust settles on that front.
What happens then to the reissue application that was paused or suspended?
The examiner can then resume prosecuting the reissue application. But, and this is critical, only after that certificate from the PT trial or reexamination has officially published.
Why the wait for publication?
It ensures the official patent file wrapper is completely up to date with the outcome of the other proceeding before the examiner makes any decisions in the reissue. They need the final official word.
Got it. Now, how does that final judgment from the PTAB or re-exam impact the claims in the resumed reissue?
Here's the absolute rule. Any claims that were canceled in that prior PT proceeding or reexamination are treated as permanently canceled in the reissue application too.
Permanently canceled, so no second chances.
No second chances. They are, for all intents and purposes, dead claims. You cannot use the reissue process to somehow revive or resurrect claims that were definitively killed off in the more adversarial setting.
Wow. That really underscores the finality of those PTAB decisions. Lose a claim there and it's gone for good, even in your own attempt to fix the patent via reissue.
That's precisely the point. Finality is paramount. And it goes further. There are also really strict limits on the scope of any new or amended claims you might try to introduce in the reissue after the other proceeding has finished.
How so?
Generally speaking, you cannot present claims in the reissue that are broader in scope than the claims that survived the PTB challenge or reexamination, and certainly not broader than claims that were canceled.
So you can't use the reissue to subtly recapture ground you lost.
Not usually. The door is mostly closed on broadening. There's a very narrow exception, maybe if the broader claims are like independently patentable based on totally new arguments or evidence that genuinely couldn't have been presented earlier, but it's a high bar.
This all seems geared towards preventing misuse of the reissue process, doesn't it?
Absolutely. It ties back to the fundamental purpose of reissue under the law, 35 U.S.C. 251.
Which requires
that a reissue application must be based on correcting an actual applicant error, a genuine mistake made when getting the original patent.
So you can't just file a reissue because you're unhappy with the PTAB outcome.
Correct. You can't use reissue simply as a tactical maneuver to re-argue points you lost, or historically, under the old pre-AIA rules, to try and provoke an interference that's a priority contest without having a legitimate underlying error to correct.
The error correction has to be the real reason.
It has to be the primary bona fide purpose. The MPP makes it clear. Reissue is a shield for fixing genuine errors, not a sword to undermine final judgments or just start new fights without proper basis.
That really puts pressure on patent owners during that initial PT trial or re-exam, knowing that any claims they agree to cancel or narrow down will have lasting consequences for any later reissue attempt.
Immense pressure. Every decision made during the contested case casts a long shadow over any subsequent correction effort. This whole section, 1449, really enforces a legal hierarchy.
Meaning?
Meaning the findings from the more rigorous, often adversarial PTAB or reexamination process take precedence over the patent owner's later attempt to fix things via reissue. The contested outcome stands firm. Hashtag tag outro.
So wrapping this up, what's the big takeaway for you, the listener navigating the MPEP? Section 1449 is essentially the rule book for maintaining order when patent correction meets patent challenge.
Yeah, it's the mechanism ensuring that the office's duty to let patentees fix errors through reissue doesn't inadvertently clash with or undermine the very serious, often final, decisions made by the PTT or during reexamination.
It's like the ultimate administrative checkpoint, a set of handcuffs almost, to make sure those validity judgments stick, even when a reissue is filed.
Exactly. It preserves the integrity of the entire post-grant system, which, leads to an interesting thought about the future.
Oh,
Well, think about the complexity we just discussed. Human examiners, APJs, patent owners, all needing to track and notify and coordinate these different proceedings, reissue, PTB trials, re-exams. There's potential for mistakes, delays.
sure, human error is always possible.
So how might future advancements in, say, fully integrated electronic filing and case management systems change this? Could we see more automation in how these conflicts are flagged, how referrals to the PTP happen, how proceedings are merged or stayed?
You mean systems that could potentially enforce these rules automatically, reducing the reliance on manual checks and notifications?
Potentially. It could dramatically reduce errors in these really high-stakes procedural interactions. It's just something to consider, how technology might further streamline and enforce these complex MPP mandates down the road.
That's definitely some food for thought. Excellent point. And on that note, we want to give a special thank you to Mike Shepard, the creative director who organized this entire MPP audio series.
Yes, thanks to Mike. And please remember, everyone, this summary was generated using AI tools. It's for informational purposes only. It is definitely not legal advice.
Absolutely. For any authoritative guidance, you always need to consult the official MPEP itself, or, of course, a registered patent practitioner. Thanks for diving deep with us today.